Good afternoon. Welcome to our live webinar, Family Law Live Q&A. It has been some time since I last done a live video. I think about 2 weeks. Nonetheless, let's get into this as soon as we can. If you have any questions, I am looking at the Advocate Mohammed Abduroaf Facebook page, the Trust Account Advocate page, where I'll be answering questions from if you have any questions. But we have quite a few questions today, 10 questions on family law. And that should take us into the next half an hour. Feel free to make use of our WhatsApp line or interact with us in whatever manner you wish to do. The first question: how do I apply for child maintenance if I do not know where the father works or lives? Should have been a question mark there. He moved to a different province and he does not want to give me details. Okay, so the Maintenance Act obviously has quite a lot of arsenal, or a lot of ways of finding people's details. One way would obviously be via a credit check, or that would be the address a person might have provided when they apply for credit, and many people apply for credit on a regular basis. Or they can contact Vodacom. You take the person's cell number, and when the person record the cell phone number, obviously they have to provide some details. Alternatively, you can get a private investigator or someone to do a bit of research, or phone the person, ask the maintenance court to phone the person, and the person would most probably provide his or her details. Nonetheless, it's very important for us to be able to determine where the person works or resides, because how can a maintenance inquiry take place without the other parent being at the maintenance court or being informed about it? Let's say the mother obtains a maintenance order that the father should pay the mother, let's say 1,000 Rand per month. I'm using a simple figure here. That order is useless because we do not know where the father is, what he does, can he afford the maintenance, can he afford much more, whatever the facts are. My advice to you, the person that posed a specific question, is approach the maintenance court nonetheless. Inform them that you do not know where the father resides or works. However, the maintenance investigator at the maintenance court would have to do the necessary investigations and determine where this person, try to find out where this person is. Obviously, you can do some homework as well. His family, his brother, his sister, or her brother and sister, ex-colleagues, people that know him or her, Facebook, Instagram, social media. It should not be too hard to find somebody's details. But if you cannot find it, you'll have to resort to other means. Via the maintenance court, if they cannot assist you, maybe obtain the services of a private investigator. Question 2 from Kwazulu Natal. I started the divorce proceedings in 2020 and appeared at the divorce court in January 2022. I still did not receive my divorce papers. Am I legally divorced without the divorce papers? The quick answer is yes, you are divorced. The moment the magistrate or the judge said he grants you a decree of divorce, usually they say it incorporating the settlement agreement or the consent paper, you are divorced. For all intents and purposes, you are divorced from the other spouse. You can immediately get married to somebody else. Whatever legal obligations you and the other party had before the judge or the magistrate divorce you comes to an end. There's no obligation to maintain, there's no obligation to look after the other person unless there's a maintenance order in place ordering to do so. But the bonds of marriages have been dissolved. That's it. So you are divorced and you can do whatever you want to do as a divorced person may. However, I would still advise you to obtain the divorce order from the divorce court. The third question, I'm just keeping an eye also on the Facebook Live. I have a son who is turning 18 in June. There is no maintenance order in place. Can I apply now for child maintenance for him from the father? Yes, you can apply for child maintenance because your son is still a minor. He is 17 years old and you have a legal obligation to maintain him, and you have the legal authority as his guardian to act on his behalf. Basically, you are acting as his lawyer in the maintenance court, representing him and of claiming maintenance from the other parent and using that maintenance for the minor child. You can start the proceedings now. The difficulty you may encounter, I'm not saying it's a problem, you should still proceed, is that if the hearing of this matter takes place after the minor child turns 18 and is no longer a minor child, is now an adult, that could be a bit of a problem. If you can be heard before June and have the matter finalized, and the court makes an order that the father should pay maintenance or the other parent should pay maintenance until the minor child is self-supporting, then obviously that order would continue until that specific stage. After the child completed high school and tertiary education, or is earning some money, the child can be 18 years old and 10 days, 18 years old and 10 days old, or is it 18 and 10 days old, and be self-supporting. He or she might have obtained a very good job, got some money, whatever the case may be. So that would be applicable there. But if the child is 18 years old and the maintenance matter is not finalized, unfortunately, you would have to ask the minor child or the child or this adult child to accompany you to the maintenance court and advise the maintenance court, here's my adult child, he's taking over the matter for himself. The maintenance court might be reasonable and allow you to be there as well, but as I said, he is an adult, and therefore he should attend to his own legal matters. Question number 4 from the Eastern Cape. I am currently engaged. I have a child of a previous relationship with my ex-husband. I want to relocate with my fiancé to Germany and get married there. The father refuses to consent. What can I do? The divorce order does not deal with relocation. Usually divorce orders will not deal with relocation. Usually they only deal with major decisions regarding a minor child. For example, the child moving to a different province. Under those circumstances, you would have to consult with the other parent. The quick answer to the specific question would be, if the father does not want to consent for the relocation of the minor child, you would have to approach the High Court for that, because you're dealing with guardianship issues. And at the same time, you might have to deal with issues concerning passport consent, because the passport would be required as well if the child does not have a passport, or the passport may have to be renewed, whatever the case may be. So, getting to the crux of the matter, in terms of the Children's Act, both guardians' consent is required for the minor child to leave the Republic of South Africa, and also for the minor child to obtain a passport. The father refuses so, you will have to approach the High Court. The High Court will obviously determine what is in the minor child's best interest. If you can convince the court, and the father cannot successfully convince the court, his case, but if you can convince the court that it would be in the minor child's best interest to relocate and live with you in Germany, and not live in South Africa, where the father would have contact with the minor child on a regular basis, it depends, that will be the father's argument, the court would allow the relocation and the passport renewal, or the application for a passport. At the end of the day, the court will determine what's best for the child. If you've done your research in Germany, what schools they have available, the facilities, X, Y, and Z, and the court can determine, you know what, the child is living in South Africa, is well cared for by the mother here, the father is a secondary caregiver, he sees a minor child maybe every second weekend, he's not so much involved with the minor child, and the option of letting the minor child remain in South Africa to be cared for by the father is not a viable option, because the father does not have the facilities, the skills, and the necessary knowledge on how to care for this minor child. That's the father's argument. He might say he has. Whatever the case may be, I focus on what is in the minor child's best interest. If it is in the minor child's best interest to remain in South Africa, that is best for the minor child. If it is in the minor child's best interest to relocate to Germany, that should happen. I fully support that, and I'll fight for that. The fifth question, question number 5, there are 10 in total. If children are not citizens of South Africa and are placed in foster care, can the foster care parents still receive a grant for them? Okay, yes, the answer is yes, you can still. You do not have to be a citizen of the Republic of South Africa when placed under foster care for the foster parent, the caring parent, to receive a foster care grant. I do not know the exact term, but yes, the foster care parent may approach the Department of Social Development for the child care grant for a foster child. So that sorts that issue out. Usually the court would, I think, authorize that. And the social worker involved in that, what happens is the parent is placed in the foster care of a third party, of a foster parent, and there's always a social worker who oversees the process. And the court would authorize that you are entitled to a child care grant or a foster care grant. As I said, I do not know the exact term. I did not have a chance to get the specific wording from the Children's Act. Nonetheless, the next question. Western Cape, my ex-boyfriend's lawyer drafted a parenting plan which we both signed 3 years ago. It is not filed in court. Is it valid? So this is the difficulty which I have. Of course, it is an agreement between you and the other party, how care and contact should be exercised. Midweek contact, weekend contact, school holidays, Mother's Day, Father's Day, special days, birthdays, religious days, and all those things are in the parenting plan. Dispute resolution, etc., X, Y, and Z. So that's agreed upon. The problem you have is if a parent does not comply with that specific parenting plan, what do? Do you go to the police station and say, you know, you have a parenting plan, the other party is not adhering to it, because it is an agreement only. You approach the court, say, you know, the other party is not adhering to it, please assist me. What do? My advice to anybody is, if you have entered into a parenting plan, either have it made an order of court or register it at the Office of the Family Advocate for to have some legal standing. It's a legal document now. It's a court order. And if the other party does not comply with the court order, obviously he or she is in contempt of court, and you can do what you have to do under those circumstances to enforce the court order, the parenting plan that was made an order of the court. Now here we have an agreement. My advice to you is approach the court as soon as possible to make this parenting plan an order of court. Otherwise we'll have this problem all the time. You'll say this is the final order, or this the final parenting plan. He might say no, we had another one afterwards. He might say he did not sign it. All those problems will arise. Or she may say, you know, I do not want to follow this parenting plan anymore because I think the father should have less contact, whatever the case may be. So therefore, yes, it is an agreement. It can mean something when you do go to court, when you do go and try to enforce your parental rights. You can say, we have entered into a parenting plan 3 years ago. We have been following it. The court will say, you know what, there has been structure in the past. Let us continue with that structure based upon the old parenting plan. But the court would make it an order of court. Question number 7. I want to divorce my wife, but she lives overseas. I live in Paarl. Paarl is in Cape Town, or in the Western Cape, sorry. Is it possible? Okay, yeah, let me at least put you in some type of background. If both parties live in South Africa, it's quite easy. The husband lives in Cape Town, the wife, for example, lives in Johannesburg. He issues a divorce paperwork here in Cape Town, and he sends the documentation to the sheriff's office in Johannesburg. The sheriff will serve it upon the mother. The sheriff will send a return of service, a document basically stipulating that the documentation was served on the mother, and it will be filed at court here in Cape Town. So the judge in Cape Town or the magistrate will see, okay, you know, the summons was served on the mother. That's quite easy within South Africa. The moment somebody lives overseas, our sheriff won't fly down there, and we do not know in that specific country do they have a sheriff. That sheriff is not bound by our laws applicable to sheriffs in South Africa. There's certain laws that sheriffs have to follow and comply with. There's magistrates court rules and the act, there's the high court rules and so on. And does the sheriff that side or that officer of the court that side understand these rules and follow these rules, whatever the case may be? So we have something called a dictal citation, whereby you can serve legal documents from a South African court on a party overseas, and that's usually done by the courts, the court should give consent for that. That's an application done to your local court, asking the court, the other party lives overseas, I have issued divorce paperwork in Cape Town, however I need to serve it on them. Please give me permission to serve it on the other party via their sheriff that side, because now the court will have to authorize that, or via email or via WhatsApp or whatever creative means there are nowadays. But the court will obviously now determine, is this fair, is it just, would it be fair service on the other party? The court would obviously want to be convinced that the email address works, the WhatsApp number works, the Facebook account works, whatever it is. I'm trying to be creative over here. Or the sheriff that side, it's a reputable operation that side, or an attorney that side as well. The court can also authorize that that attorney, that specific country, can go to the defendant or the other spouse and serve the divorce summons on that party, or give it to the other party and give an affidavit or document stipulating that he gave the divorce summons to the other party. So that is possible. Long story short, to summarize that issue, you'll issue the divorce paperwork in South Africa, in Cape Town, locally. You will approach the court, asking the court permission. Can I serve these documentation on the other party by email or any other alternative means? The court will authorize it, and then you serve the documentation. You get a return of service, or you get proof of service of the digital citation, either an email receipt or some document from someone that side, and then that part of the process has been complied with. The documents were officially served with the court's consent via that specific means, the digital citation. Second last question from Gauteng. I pay maintenance, but I am also being denied access on weekends. What can I do? Okay, there's no gender here. My advice to you is to approach the children's court as soon as possible, and the court will ultimately make a decision as to what type of reasonable contact you're entitled to, what's in the child's best interest. If it's in the child's best interest for you to see the child every weekend, half the weekend, whatever it is, the court will make such a decision. Maintenance and care and contact are two separate things. For example, a parent cannot say, you know, I'm entitled to have contact with a minor child every weekend, but now I'm paying double maintenance, give me now double the time. It doesn't work that way. It's two separate issues. And in the same way, if a father says, you know, I cannot afford to pay the child maintenance, I can pay zero, it does not mean he should not have any contact. He can have maybe more contact than many other fathers have that's paying a lot of maintenance to the minor child. So my advice to you, questioner, please approach your children's court or your attorney or your advocate, and maybe approach the High Court if you want an urgent application to be launched. The last question, question number 10 from Gauteng. I want to change schools for my child. The school says they need both my and my ex-husband's signature. He says he will agree but not pay the extra. What do I do? So we presume here that the new school or the intended new school is a bit more expensive. The father said, fine, the child can go to whatever school you want the child to go to, but I'm not paying extra maintenance. The X amount of money I'm paying per month is the cap, and you can pay the balance if you want the child to go to a different school. It's a very difficult one, because if the father can only afford to pay that X amount of money, and you want the child to go to a different school, then you have to obviously pay that, and maybe approach a maintenance court afterwards and apply for an increase. That might be the best way to deal with the matter. If you feel, you know, you do not want to be bullied by the father, and you think that he's being unreasonable, you may approach the court and also court dispense with the father's consent and let the child anyway go to that specific school. I will in the meanwhile pay that extra amount of money, and I'll approach the maintenance court later on for an increase. I think it will be difficult for the court to order the father to pay the extra amount of maintenance if the court, without the High Court or the court dealing with this matter, doing a full-blown investigation into the affordability of the father to pay this extra school fees. So it's a bit of a difficult one. Maybe the father had to be super wealthy and the school fees is very marginally different. The court might make a robust decision, but it's two different aspects, the consent aspect and the one of forcing the father to pay the child maintenance. So these are one of the difficult ones I deal with on a regular basis. How do I deal with it? So my advice generally is, ma'am, get the child, get a provisional consent from the school that the child can go there. The father's obviously refusing. We go to court, we get the court to say, no, the child can go there. Then afterwards you approach a maintenance court to get additional maintenance from the father, if he can afford. If he cannot afford, too bad, you have to pay the balance, mom, in my example, or in this example. I see no questions on the Facebook Live. Thank you very much for your time. Thank you for watching, and I hope to see you online again soon. Have a lovely day.